Welcome to this week's episode of Strictly Legal on WESN Content Capital. I am so grateful to be here. I'm so grateful to be back once again after such a long break. However, we are ready to bring the law on you. Of course, you can stream us on WESN CC and all social media networks, including our podcast, Strictly Legal with Rondell Donowa. How have you been? I hope you have been well. I hope you have been keeping safe and sound. Of course, let's get right into it. We have now our Legal Lingo segment. Now, today's Legal Lingo is jury trial. Now, let's see the definition. A jury trial involves a group of jurors who determine the facts and deliver a verdict, while the judge handles legal matters, including what evidence the jury can consider. In murder trials, there are 12 jurors, and in other cases, 9. Jurors are selected from the voter list to represent a diverse cross-section of the population. Now let's give a case example of a jury trial. Now let's use the name John Doe. John Doe is charged with murder and pleads not guilty. His trial takes place in the High Court, where a jury of 12 individuals is selected from the eligible voter list. The jurors come with various backgrounds representing different races, genders, and age groups. Throughout the trial, the judge addresses legal matters, ruling on the admissibility of evidence, and instructing the jury on relevant points of law. However, it is up to the jury to listen to the testimony and assess the facts of the case. After hearing closing arguments and the judge's final instructions, the jury determines and deliberates and eventually delivers a unanimous verdict on whether John is guilty or innocent of the charges. And of course, there may be a hung jury, and we will chat about that. So that was Legal Lingo. Let's take a break. We'll be right back.
We are tackling the hard-hitting topics, some controversial topics, some topics we sweep under the rug. You don't always have to forgive in a relationship for it to move forward.
If it is you are in a situation where you forgive the person, but to the detriment of yourself, what are you really doing?
It is very uncommon for somebody in the younger age group to have dementia.
Atheists don't not believe.
Is that I can't disprove God, but you also can't prove God, so we kind of have to stalemate.
We'll focus on the woman who's being the victim,
right,
or the man who's being the victim. We exclude the children.
Folks are trying to study the underlying brain mechanism to figure out how does this particular disorder happen in the brain? How is the brain processing this?
Don't worry about AI. Worry about humans working with AI.
Are you willing to learn new skills to stay relevant for the future job market? That's the challenge that people are going to struggle with.
And welcome back to this exciting edition of Strictly Legal on WESN's Content Capital. Not forgetting our traditional media as well as social media, WESN CC, and our podcast, Strictly Legal with Rondell Donowa. Today's episode, we are speaking about justice on trial, the debate over jury versus judge alone trials. So many times you've been hearing in the media about jury trials, about someone who's getting selected to be a juror. And of course, the recent introduction of judge alone trials, whether or not it is effective, whether or not it speeds up the course of justice. And I have none other than Israel Khan, Senior Counsel, once again in studio to present us on the topic and to have our discussion in terms of the advantages, disadvantages, and the development of law with respect to jury and judge alone trials. Hi, Senior. Good day, once again.
Good day, Donald.
How are you?
I'm fine, thank you.
Nice. Good to see you, and thanks for always being willing to come on Strict Legal, as I would have to say my resident senior counsel guest.
Yes, it helps.
Yes, and of course, you know, I know that you have, I mean, you are a practitioner in law for the past 30 plus years or 40 plus years, and you have extensive experience when it comes to jury trials. Now, Mr. Khan, can you explain the historical significance of trial by jury in Trinidad and Tobago in the criminal justice system? Has it, I mean, this is something that has been evolved from the English legal system?
Well, early in the 14th century, after the Bill Magna Carta, in England, they curtailed the sovereign power to interfere with the justice system. And that the jury in England usually will bring in a verdict in keeping with what is the king wants. But however, with the development of the law and the rights of the citizens in England, they were able to establish trial by jury. And when England settled Trinidad by conquest and made it a colony, and then annexed Tobago, and Trinidad and Tobago became a colony of England. They implemented the system of justice that they had in England for the inhabitants of Trinidad and Tobago. And therefore, we can say quite a few hundred years, from time immemorial, since England had jury trials, that is, the accused will be tried by his peers. They implement that system of justice for Trinidad and Tobago. What was good for England was good for the colonies, be it Australia, New Zealand, India, Canada. They implemented the system of jury trial. That is, very serious offenses will be tried by the ordinary citizens of the country.
Now we say ordinary citizens, but many persons have argued, can an ordinary person really understand and appreciate evidence when it comes to a trial and to give a proper verdict outside of emotion?
Well, you see, it's both a judge and the jurors, the jury, who try a criminal matter. And the judge will understand the complexity of the law, and what he will do is simplify the law so that the ordinary people who consist of the jury will understand the legal direction. That he will tell them, for instance, the accused is presumed to be innocent. There is no onus cast upon the accused to prove that he did not commit the act. The onus is upon the prosecution to prove that he's guilty, and they must be satisfied beyond all reasonable doubt. He will explain what that means. He must be satisfied to the extent that they feel sure that the accused is guilty. If you are not so satisfied, then you should acquit the accused. He will simplify the law for them.
Now let's go back in terms of the selection of a juror. Now, obviously, from my example, I mean, a juror is selected from the electoral list.
Yes.
Not so. But in terms of a cross-section of a society, does the jurors really represent the cross-section of a society of Trinidad and Tobago when selected? How does the procedure go when juries are selected?
Yes, they definitely represent a cross-section in society in relation to religion, race, political allegiance, educational background. They represent a cross-section because they come from the voters list, and they're not selected on the grounds of they're more educated or they're middle class or the 1% of the population. They come from every background. So definitely they represent the society.
And in terms of when a trial is, before a trial is started, you have the, is it called the arraignment? Do we use the term arraignment?
Yes, charges read,
right,
etc., etc.
Now, for persons who may not know or may not have entered a court, how are the jurors now selected to sit at a particular trial?
Well, they come from the voters list. Like, for instance, if a matter is being tried in Port of Spain, for convenience sake, the jurors are selected from the voters list from Toco right down to Caranage, in that area. If it is San Fernando, they're selected from Rio Claro to San Fernando. So they come from the general population of the country, and the judge would not know who the jurors will be. The lawyers, prosecutor, and defense attorney would not know. And they're selected at random.
But then when they arrive at court, is there a process in terms of the prosecution and the defense counsel deciding on which juror should hear their case, or in terms of the process of objection? Because obviously, I mean, as seen on TV is not probably the same as in our jurisdiction. Now, in terms of finalizing that 12 in a murder trial, does the prosecution and the defense has the capacity, or rather the authority, to object to a juror on what basis?
Well, for one accused, let's say on a capital offense, we'll select 12 jurors and maybe alternate if something happens. So one of the members of the panel, that person on the alternate panel will take up that position. The prosecutor has 3 exemptions without cause. They don't have to give a reason. They just object. And the defense, for each accused, will just object. They don't have to give a reason. They just instinct will tell them, well, for whatever reason, they're objected. So it's equally balanced. And if there is just cause that maybe we have information that the juror might be biased against the state or the accused, you would have a hearing, a short hearing, and the judge will decide whether the juror is impartial. So that is how they are selected.
And is there any way that a juror can decide to recuse themselves from being part of the process?
Well, they could make an application to the court, and they must give good reasons. Like, for example, they could say they're against the death penalty, and for murder, if the person is convicted, he got to be suffer death by hanging. And the judge will indicate that is not a sufficient reason for you to get an exemption. The punishment, you have nothing to do with the punishment. What you have to decide is whether the accuser is guilty or not guilty.
And then sometimes persons may make frivolous excuses where I have work that would exempt one from jury trial, or who is exempted from sitting on a jury?
Well, a person will have to give good reasons. Like, for instance, like they're about to leave for the country, and this trial may take more than, the judge will indicate how long the trial will take, and they will not be able because they're due to go to university or they're due to pick up a position. Various reasons. The people who give trouble is people who are upper middle class and middle class, who are entrenched in the system. They think, well, that is a problem of the proletarians, the working class people, and I don't wish to go to court to hear whether a person is guilty or not guilty. They are sort of abscond.
And that certain officers of our society exempted from jury service?
Yes. And the spouse of lawyers, policemen, judges, magistrates, certain people who may be acquainted through other people with the evidence, they exempt them.
All right, and so now that we have satisfied in terms of what is a juror or how a jurors work, I mean, when we go back to some years ago, the Honorable Chief Justice, in his speech at the beginning of the law term, would have raised some concerns with respect to jury trials, which would have contributed to the delay in the administration of justice. How do you respond to those criticisms now that we have now passed laws where judge-alone trials are an option?
Yes.
And I mean, of course, we would speak about whether or not that has been successful to date.
Well, to answer that, the public must understand that trial by jury is an integral part of a democracy. Government for the people, by the people, on behalf of the people. And the preamble to our Constitution makes provision for citizens to participate in the national life of the country. And what could be more national than participating in the delivery of justice on behalf of the people of Trinidad and Tobago? That's what they must understand. It's a duty that they are performing, and they must really come forward and serve. So trial by jury is indispensable to democracy, if it means anything like government for the people, by the people. So it must not be tampered with.
But then the argument in terms of the jury trials contributing to the delays, as we have seen for a number of years. I mean, this is a society that has a lot of murders. I mean, the detection is another thing. But persons who are now on trial for these offences, it takes years, and rather we will get to the point where now there are certain circumstances where persons are now stating that there may be tampering of these jurors.
Well, first of all, in my 45 years of practice at the criminal bar, I have never come across any information or any evidence that jury tampering led to the acquittal or the conviction of an accused person for murder and other serious offenses. There have been jury tampering by people approaching jurors and so on, and most that will happen, it would result in a hung jury, that the person they cannot come to a unanimous verdict or majority verdict in a non-capital offense, and the person got to be retried. That is a small price we must pay for having trial by jury, because many of our scholars who study the jury system and practitioners know that if they abolish jury, it will be a weapon in the hands of the government of the day, who can, through various means, influence a judge alone to bring in a certain verdict. You see, it is more difficult to tamper with 12 persons or 9 persons than a single judge. A single judge could be reached. He could be threatened. He could be bribed. It's one person. But almost difficult, it's very difficult to bribe 12 jurors.
But if we were playing devil's advocate, looking at the civil jurisdiction of things, one could argue the same thing. However, there's no evidence to show that one judge has been bribed in a particular matter.
There's no evidence, because if there is evidence, he would have been charged.
Right. So the same argument could now use in terms of judge-alone trial for criminal matters.
It's 12 persons or 9 persons. There are certain. They don't think the judges vote on election day. They have a certain bias. They don't think the judges have biases coming from the entrenched intelligentsia. Subconsciously, they could have bias. The jurors come from different backgrounds. They could understand what's happening in the society. They will be more accurate with police brutality, planting of evidence, consent or no consent to date rapes. They could understand what takes place. A reasonable doubt they will have. A judge is highly trained, and he may see the evidence clinically. And therefore, he is one person. Like, let's take, for example, mistaken identity. A judge will warn a jury that mistaken identity could take place because the person, the suspect who committed this offense might fit a certain description. Let's say they give a description of a brown-skinned person with curly hair, a certain height, and what he is doing is giving a description like somebody from St. James of Big South Century, like what we call the Trinidad Douglas. You know how many hundreds of people that description fit? So somebody could make a mistake in identifying the person resembling the suspect. So a judge would look at other evidence to see whether it supports the description and the perpetrator, and he would not be looking really so much at what the witness who is saying this is the man, whether he could have seen properly and make a correct identification. And the judge must warn himself, warn the jurors that mistake could be made. So the judge will warn himself that I can make a mistake, but nonetheless I believe the evidence to the extent I feel sure. Like in date rape, a person may honestly believe that the prosecutrix, the voter complainant, is consenting, because the person may not consent because they may not resist, so they ought to resist, and a middle-class person may resist in a certain way than another person, etc., etc. The ordinary jurors are in a position to better judge that concept of consent or no consent, another judge.
But so therefore the right to choose based on the law now requires, or rather is such that one can select whether they would like to be tried by jury versus judge alone.
Yes.
In what particular circumstance is it any particular type of offenses?
Well, as it stands now, all offenses, but they were attempting to really say that if you want to have a judge, but that bill was not passed, if you want a judge alone trial, you make a request of the judge, and the judge will decide whether in the interest of justice you should have a judge alone trial, a jury trial. Now, that is really taking away the rights of the accused. You see, judge alone trial didn't land on our doorstep just like that. At common law, there was a legitimate expectation that if you're charged with a serious offense, you will be judged by your peers. There is a constitutional right to be tried by judge and jury, in spite of the fact it's not included under the fundamental rights section of our Constitution, but it states that your right to life, liberty, and security of the person, you cannot be deprived of this right without due process. And due process has been developed into meaning they should be judged by your peers and it should be selected and so on. And if you want to interfere with that right, you must have a constitutional majority in Parliament, and you could enact legislation to take that right away if it is reasonably justified in a democratic society.
But then, have you presided, or rather, have you advocated in a judge alone trial based on your client's instructions?
Yes, a murder trial in which a police shot someone in self-defense. You see, you would only take a judge alone trial if the evidence is not complex and it is not circumstantial and the evidence is strong for the accused. Putting the life of an accused person in the hands of a judge alone is a dangerous thing, because the judge could say, look, I warn myself that if the evidence is weak, I should not convict. But in spite of the weakness of the evidence, on the totality of the evidence, I am sure beyond all reasonable doubt the accused is guilty. So he is warning himself, and himself is rejecting the warning and coming to a conclusion of guilt.
But then, that is where, I mean, the option of appeal comes in terms of, okay, if one finds that the judge erred in law or in fact, right, this is where the person stand accused is entitled to appeal that particular decision.
Well, in relation to the finding of fact, a court of appeal cannot retry a case. Once there are finding of facts by the fact finder, and they didn't take extraneous matters into consideration, the finding of fact cannot be easily interfered with.
But this finding of fact is by jury or by judge?
By both judge and jury. Remember, if it's a judge alone, he becomes the jury and he's also the judge. So they would not interfere with a finding of fact by a judge alone, unless it is patently clear. So therefore, they could only interfere if the judge gave himself wrong directions on the law to apply to the finding of facts he made.
And let's look at, we mentioned before jury tampering. We've had a recent Privy Council decision in a DJ Palmer, the Vibes Cartel matter, in which the Court of Appeal was of the view that there has been some interference or there has not been misguidance with respect to the approach to the jury. So therefore, a judge, even if there's a jury, a judge can basically guide the jury incorrectly.
Yes, of course. But in that particular matter, I think that was a superstar in Jamaica.
Yes.
And he was being tried. And one juror approached another juror and indicated he would get $500,000 if he make a certain finding. And he was trying to reach other jurors. One juror did that. And the judge, the particular person reported the allegation of the bribe to the foreperson. And the foreperson did not indicate to the rest of the jurors that this bribe was made to the particular juror. And what the judge did, the judge had an inquiry. And the judge found as a fact that the other jurors were not contaminated, but this particular person, he was asked to step down. And then they asked the foreperson that if what she heard about that particular juror, whether she herself will be fearful of rendering a verdict. And she was hesitant to answer, and then she indicated that she could give a fair trial, and the judge allowed her to sit. And they found the person guilty, and they did not interfere with the judge's ruling. But the court should have gone further. They shouldn't take the word of that particular foreperson that she did not contaminate the rest of the jurors by telling them, and that remained intact. That case is a very unusual case, and it's not a good precedent. What will happen in other matters, they will inquire of the jurors, and a juror could lie. A juror could say, no, I could render a verdict, a fair verdict. I could give a fair verdict. So that is a very unusual matter. That case cannot be used really a template or a precedent.
But it's something that has, something has now led to one's acquittal, to much delight of many because of their status. But it goes to show that in even the Commonwealth jurisdiction, even our jurisprudence, it can happen. Persons who, of course, obviously of all walks of life, persons who may be seeing the easy opportunity for monies due to the hard, the hard life that is ahead of them, all these different things. It may not have happened here, I'm not certain, yes. And you can correct me, but these are the fearful things that, the state, or rather persons who the stakeholders, the Chief Justice or whomever, would have concerns of.
That is a subterfuge by the Chief Justice for mismanagement of the judiciary and expedited matters. There is no evidence that trial by jury is causing a delay. Absolutely none. It's not causing a delay. What is causing a delay really is that there are too many cases reaching the assizes and a limited number of judges to hear these matters. And once a matter starts in the assizes, it takes a long time, either 3 weeks, 3 months, or could take 2 years. Even John Ipol case took 3 years. And the Chief Justice found it necessary to look for a scapegoat, that saying that the jury is causing delay. What is causing delay is that the law as it now stands is that, let's take for instance murder. If you plead guilty to murder, unless it's a felony murder, that is you kill someone, a commission of a robbery or something. If you are found guilty, the penalty is death by hanging. Nobody will plead guilty to murder. So they go to a trial. And it will take 3 months, sometimes 6 months to determine a matter. If they categorize murder into first, second, and third degree, and reserve capital punishment for first degree, and a term of imprisonment for second and third, that will ease the burden in relation to plea bargaining and people pleading guilty, knowing that they're going to get a sentence of imprisonment. And if they have a parole board, that the personal right on good behavior could return to society, and if they misbehave, they return to prison to serve out their sentence and so on. Also, the Director of Public Prosecution Department is starved for resources. He is short about 60-something lawyers to prosecute. So how can they expedite matters when the prosecutors are not available to the judiciary?
Now there is also, I mean, again, it goes both hands. I mean, one could argue that whereas the judiciary is trying their utmost best to expedite matters, there are other arms of the states that needs to also put their all hands on deck to ensure efficient or effective means of justice.
Well, there are the cases, what we are dealing with the cases pending in our sides, because what happened, the police would have gathered up the information. They might have a sufficiency hearing saying you've got to be tried by judge and jury, and then bottlenecking in the assizes, too many. Plea bargaining would assist. But all over the world where you have this system inherited from Great Britain, they're having this problem, you know. Because first of all, there's a presumption of innocence. Then secondly, the state will provide legal aid for you if you do not have an attorney to represent you. Then there's a presumption of innocence. Then the evidence must be cogent, compelling, and convincing. Then you have the right to cross-examine. Then you have the right, and so many safeguards for an accused person. It seems that they cannot expedite matters. So it's happening all over the world, not in Trinidad and Tobago, but Trinidad itself, when you have to wait 10 and 12 and 15 years sometime for a trial, this is really atrocious in that it's against the presumption of innocence to lock a man up. Look, let's take the case of Dana Sitahal. It's 10 years ago that they charged 12 persons for her murder. And it's very unfair to the accused men who have been incarcerated, locked up, and they have not received a date for their trial. It's unfair to the accused men, it's unfair to Sitahal's relatives, both sides. These persons are presumed to be innocent until proven guilty, so they must expedite the trial. And this is a glaring case because it's a high-profile case. But there are other cases.
And they have spent a particular length of time on remand.
Yes.
Yeah.
It's morally wrong. And they do not have the right to a speedy trial in Trinidad. You know. You have a right to a fair trial. And if delayed a trial will cause you not to have a speedy trial, it's only then the court will intervene.
Now, what about the fact that the legislation of a JIPA has now come into play in terms of Administrative Justice Indictable Offences Act and Proceedings Act. I know I had the Chief Public Defender on my program recently. But now with the advent of that particular piece of legislation, where masters now have been hired to direct or a better flow of matters to be taken to the assizes for trial, how has that now impacted on the functioning of the judiciary?
Well,
particularly, not only the judiciary, but in terms of expedition or expediting matters. I mean, I know we've segued a bit, but...
Yes. That impacted upon the criminal justice system in that the matter of an entitled matter is not stuck at the magistrate court, where the lawyers have the right to cross-examine, and again, they will cross-examine all the witnesses and have a full-blown trial. What will happen now, it goes straight to a master to look at the evidence that has been filed, and if there's no objection to any evidence, that the evidence, even if there's objection and a judge must decide on the admissibility, the case will be listed for hearing. What it has done, it has really moved away the delay at the magistrate court. But it's only recently, about a year ago, that this came into existence. We have to see how it's impacted upon trials at the assizes have been expedited. And I suspect there will be a bottleneck because we're shorter judges and we are shorter the prosecutors. It will bottleneck. It will go back. It will go back to delay unless the masters, if you cannot go to a trial, they say within a certain period, let's say 2 years, the matter will be dismissed. Well, let's see if a master is going to dismiss a case of murder when the evidence is strong, but the DPP cannot prosecute because he's short-staffed. Let's see what they will do then.
No, let's go back to the fact that jurors, or rather, our society is one now that persons are, let me say in local parlance, they're fed up of crime. Obviously, now that is played on the psyche of an individual, and therefore it means that there may be some argument that persons who have been selected for jury service will now have a subjective approach because of that incensed nature of crime, and you just want to have a conviction.
Well, the judge will warn them, and one is expected to abide by the directions the judge would give, even if crime is a problem in the country, that to listen to the evidence. And the evidence must be cogent, compelling, convincing, and credible. And if the evidence is cogent, compelling, convincing, and credible, if you are satisfied that the accused committed this offense, you must convict. And usually they will convict unless there's jury nullification. That means in spite of the evidence, the jury, all the jurors decided to acquit. That happened for example, a good example is the O.J. Simpson trial, where the evidence was cogent, compelling, and convincing. But the jurors in that jurisdiction took up a different position. They didn't trust the scientific evidence, and other happenings in the society, because Rodney King was brutally murdered around that time, etc., etc. And they return a verdict of not guilty in spite of the evidence. And that happens throughout America, let's say with the anti-slave law, that if you protect a slave who is trying to get to Canada, he will be charged. They kept on rejecting the evidence. That happened with abortion. The guy called Morgenthau in England, the evidence was clear, and they believe a woman has the right to decide whether to bring her child into this world, and they just started to acquit. Lord Devlin says that the conscience of the jury will decide whether an accused person should be punished for a particular offense. So that is the system we have. You know something?
Yeah.
There was no law saying in England that slavery is illegal. They were enslaving people for 300 years. And they didn't say it's illegal. But suddenly one day they got up and said, look, you know, this thing is illegal. Nobody was saying it's illegal. They didn't have to pass a law saying that it is illegal to involve yourself with slavery. It was beneficial to England to have slaves in the colonies. So those who control the economics and the society control the justice of the country. That's why it's dangerous to abolish jury, trial by jury. Very often you'll hear in our parliament that across the board, on both sides, accusing members of parliament of being involved with criminal acts, or they are in charge, and so on and so on and so on. You think it should have a right to be tried by a judge alone? Who do you think select the judge to sit there? Is the Judicial and Legal Service Commission headed by the Chief Justice, who is selected by the President of the country, and the President of the country is selected by the Cabinet of the country?
I mean, it's something that has been, part of our Constitution for years.
That means to say it right. What has happened, we're very fortunate that Trinidad is a multiracial, multi-religious society, that in spite of the fact that how we party is not how we vote, and how we vote, when they get into a court of law, they do not allow race, class, or creed, or political allegiance to get in their way. They listen to the evidence, they listen to the lawyers, and we have been doing well in our courts of law in rendering justice. Strange as it is, but when coming to vote, it's two different things.
Yeah.
And that doesn't humbug me as a criminal advocate. That is a different kettle of fish.
So is it that, some persons may ask that, can a judge direct a jury in such a way to compel them to issue or to reveal a guilty verdict?
No. You cannot do that in plain and simple language. But you could play upon the emotions and have a way that the judge could direct the jurors, because subconsciously, you see, a juror has prejudices. And they could work on that in a certain way. Therefore, there's where the defense and the prosecutor come, they play a role in telling them to disabuse their mind from any preconceived ideas you may have and so on. But to answer your question, you cannot direct them to return a verdict of guilty. On certain instances, you can more or less direct them without upholding an okay submission, indirectly to arrive at a verdict of not guilty, but not in relation. Being guilty, he would have usurped the function, the sacred function and prerogative of the jury, and that will cause a retrial if the person appeal. So you really cannot do it blatantly, but he can do it.
And I guess that those are things, obviously, that persons may argue against, but there's no empirical evidence to show that in Trinidad and Tobago's jurisdiction, judges has directed jury in such a way, unless the judge is very smart and experienced,
yes,
to make certain pronouncements before the jury retires to deliberate, to arrive at a verdict.
A judge may be summing up a case, and what he is saying viva voce is recorded. There is no recording of him when he's given them direction. And he will indicate, well, the accused gave evidence and he said so and so. If you believe, and he will do that, if you believe that, and he put his hand like that and convey to them, it's only a fool will believe that, because it's body language. And little things he may do and so on. Therefore, it's when the defense counsel, if they're strong enough, will indicate to the judge they would like to have a word with him in his chambers or out of the jury hearing, and indicated very strong language that by your body language you are conveying to the jurors that they should interpret the evidence in a certain manner, and so on. And you have to be a strong lawyer to do that. because the judge will be angry with you, but you have to be stronger than the judge.
Yeah. But I guess that's where probably people like you, senior counsel.
Well, all senior counsel in the criminal arena advocates, they're strong enough to do it and
yes,
do it.
Yes. And that sometimes directs the judges as well.
Yes, because they too could indirectly attack the integrity of the judge. But they had to do it in a very civilized manner. For a time, our lawyer said, with the greatest respect, my Lord Mayor, for a time he said, with the greatest respect, he's going to attack the judge.
Yeah. But it's just a way to soften the blow.
Yes, he may not tell him that you are deliberately manipulating the evidence. You tell him the greatest, you should take a different perspective. They talk a certain way that the public would know that they're telling the judge, look, you're biased.
Yeah.
We speak a certain language.
Indeed. So let's talk about jury nullification. That particular concept. How do you explain that concept of jury nullification and how it might operate in our justice system for persons who
you do not have the right to indicate to the judge that you should indicate to the jury about jury nullification, meaning in spite of the evidence, if it's against your conscience, or quit. You cannot do that. Jury nullification is when there is evidence to convict and you are quit. I suspect jury nullification came about in the eventual Naipaul case because they had so many people charged for a particular murder, and the person who really organized for kidnapping, for ransom and so on, he escaped while the case was pending, and he was shot by the police in a shootout with the police. And also, the evidence was such that only 2 or 3 persons might have actually done the kidnapping and the shooting of Naipaul. But going on joint enterprise, the jury, after hearing 2 years of evidence, decided, look, that these young men sitting in the dock, they ought not to be convicted for what 2 or 3 persons would have done. And let me tell you something about jury trial. It's not only how we look. The jurors are not far, the jury box is not far from the accused. The jurors sometimes identify with an accused person by smelling the accused. His smell is similar to their smell. Subconsciously, that sense of smell in their mind, they start identifying how the accused look, his mannerism, his class background, and all these things they take into consideration. So subconsciously, they might have a prejudice against the state to acquit. The prosecutor is the one who must be astute and cunning enough to understand all these things. Not many people understand smell is a powerful incentive or no. Not many people. That is very important because subconsciously you identify with the person. Also how they look, how they smile, etc. So it's a hit and miss thing. The jury system is not infallible.
I mean, at the end of the day, they are human beings you're dealing with.
Yes, and if you're locked up for 10 or 15 years, they believe that was sufficient punishment.
Yeah.
So if you expedite the matters and you soften the blow in relation to murder, you will not be executed for 2nd and 3rd degree murder.
Now you mentioned that for 2nd and 3rd degree murder. I know we don't have that in this jurisdiction. I mean, I know that is something that you have been advocating for in order to allow for a better flow in terms of how case management is with trials. Yes. Can you just explain why 1st, 2nd, and 3rd degree classification is sort of needed here in order to have some quick access to justice?
Well, first of all, the Manning administration, some 20, 25 years ago, set up what they call the Prescott Commission to inquire into capital punishment. The PNM government set up this commission, and the commission recommended that they must have first, second, and third degree murder 20 to 25 years ago. And they have been in on and off it for most of the time, and they haven't implemented. First degree murder is when the murder is deliberate, it is atrocious. Like if you take a fee to kill somebody, and you just go and kill that person, that's first degree murder. Second degree murder might be use excessive force in self-defense. You had no intention to kill, but defending yourself, you use excessive force, it'll move away from self-defense into a sort of a revenge. You lose control of yourself. Or for that provocation, you provoke. Like if there's a dispute, husband and wife, and one of the spouse stabbed the person, and unfortunately the person died, that'll be either third or second degree.
Yeah.
And that could be made bailable. You'll receive a term of imprisonment. Or you abolish the death penalty for murder. If you abolish the death penalty for murder, you'll get more convictions. You know. People don't like to sentence somebody to hang, you know, unless they feel sure. And the government of the day would not do it. The partnership government did not do it. Why? Because it's not a popular thing to do in relation to the votes. You can fool some of the people all the time, but you can't fool all the people all the time.
Yeah, but it's necessary because at the end of the day, when last was there hanging? So it obviously appears that persons are being who have been sentenced to hang, they are spending life in prison.
Yes.
So what's the difference between just amending the legislation to that effect?
No, but what happened, the law was existing when Dole Chedi and the others were convicted, and Ramesh Maharaj moved expeditiously. And they were all executed. And then the Privy Council decided that an accused who have been condemned to death have the constitutional right to be suffered death by hanging within 5 years.
Yeah.
That is his right to be hung or hung within 5 years. And if you can't do it, then it should be commuted to life imprisonment or a term of imprisonment. They used to have execution for pickpocketing in America, in England, you know.
At one point in time?
Yes, at one point in time, yes.
This is very, I mean, I must say this is very interesting. So tell us in terms of your views, what reform, if any, should be considered to improve the current jury system without dismantling it, if at all?
Well, like what we are discussing here, people will look at this show, they'll be interested. Introduce elementary course for elementary student about the civic duty to serve as jurors. Have a course at high school, at the university, indoctrinate the people, because it's a great thing for ordinary people of good character to participate in the delivery of justice on behalf of the people of Trinidad and Tobago. During slavery, you think our forefathers had that right? Never had that right, but the founding fathers of our Constitution make sure that they had the right to life, liberty, and pursuit of happiness, and you cannot be deprived of this right. And there's a legitimate expectation you'll be tried by your peers. That shouldn't be interfered with. That is a weapon in the hands of the government of the day. And people have made the point. It's the last bastion. I think the principle of the UWI indicated with a classist and elitist society, this is dangerous to interfere in trial by jury. Why you don't want the ordinary people to participate in justice? Why? Because the Lord have then made a point. I made a point also, there's only a dictator or a fool who will interfere with trial by jury. The president, then president of the Bar Association, Pamela Elder, said she will burn her robes instead to go to court without a jury. I do not think the government wants to interfere really with trial by jury. It's a distraction.
And at the end of the day, how do we deal with ensuring that justice delayed is not justice denied? You know?
I have indicated what you must do. First of all, is under the doctrine of separation of powers.
Yeah.
Is that we have three branches of government: the legislature, they pass the legislation; the executive, that the prime minister is cabinet, they implement the legislation, and the judiciary interpret the law. They have interplay between the three branches, but one should interfere with the other. First of all, if the director of public prosecution is in charge of all criminal prosecution, you must give him the necessary plan and tools and resources. You cannot starve him of lawyers. You must have the lawyers to prosecute. You must have the judges. The chief justices are asking for better wages, if I could call it wages, salary or whatever, for his judges. But find out how much a judge gets and see if that is sufficient, or whether it is high in relation to other people. What are the terms? It's not only the judges we have. What about the doctors in the country? What about the engineers? What about the roads? What about the health centers, community centers, employment of poor people? What about Lavantil and Cover and all these people? You have people really not equipped to take care of themselves.
Yeah.
So you have to know how we allocate the resources.
Indeed, and that's, of course, that is a discussion for another time in another venue.
Well, what has happened? The political system in the Caribbean, especially in Guyana, Suriname, and Trinidad, you have two main tribes. And Indians in Trinidad and Tobago tend to support our Indian party, and the Africans tend to support our African party. And we have PNM, UNC, ULF, or whatever they call you. It's the enlightened people from both tribes, both races, will have to decide whether they are satisfied, because there's only one topic is causing the floating votes to be concerned. That is their safety and crime.
And how do we treat with that? But Senior, I know we
how we deal with that? First of all, you have to rule out all the corrupt police in the police service. And you can't say there's no corrupt police in the service. We have been hearing time and again that certain police officers have job blocks. Certain officers have been bribed by criminal elements and so on. I do not know if they can get the evidence to prosecute and weed them out. And it's time they upgrade the education of police officers.
Agreed.
But all over the world, they need some police officers who are dumb enough just to take instructions and not to question anything. All over the world.
See there, this is segueing into another topic that I believe we may need your guidance on another day. We are out of time, I must say.
Yes, yes.
So Senior Counsel Israel Khan, thank you so much. This was Justice on Trial, the debate over jury versus judge alone trial. And I'm sure that even your students and even practitioners alike will be grateful for viewing this and our replays, which will be on our podcast as well as on our YouTube channel. So thank you so much, Senior.
Well, thank you for having me.
Yes.
It helps with the system.
Indeed. Guys, it is a wrap. Thank you so much for watching WESN Content Capital. I am your host, Rondell Donowa. And before we go, I leave you with this quote. Hard things will happen to us. We will recover. We will learn from it. We will grow more resilient because of it. Taylor Swift. Have a good day. God bless.
Thank you. Finish?
Yes. Yes, we finished.
I hope
we take my heads. Time to wrap up. Time to wrap up. Yeah. you.